Hello everyone, welcome to Management 413 Employment Law here at the UAB Ch School of Business. In this video we will be covering harassment using Chapter 9 of our textbook. Here's an outline of what we will be covering with harassment, that it is a form of illegal discrimination, usually based on sex, how to recognize harassment, what's the liability for harassment, particularly for the employer, and how do we eliminate harassment in the workplace. Harassment is, I'm sorry to say, a major obstacle in many workplaces today, and for all of you who will become HR professionals, it will become a part of your lives to figure out how to respond to reports and how to prevent it. Most complaints of harassment are sexual harassment, but there are plenty of situations involving non-sexual harassment, what we might call workplace bullying. Workplace bullying is not clearly illegal, but it is increasingly against many employers' policies. That is bullying that is not based on sex. UAB, for example, has a policy that clearly does not allow bullying, even if it is not based on sex. Here are the elements of a claim of harassment. Note that there has to be a tangible employment action taken, or there has to have been created a hostile environment. We'll be talking about those 2 points in a minute. The way to challenge harassment is under the anti-discrimination laws, and the reason for that is that the courts have increasingly held, it's now very well established, that when sexual harassment does occur, it represents a treatment of someone based on sex, which the Civil Rights Act of 1964, Title VII, does not permit. It is not based on any sort of federal law, at least, that bans harassment. There may be harassment laws at the state and local level, but we are talking about Title VII here, which is, for the most part, a useful tool in combating harassment. Same-sex harassment can be more difficult to combat because the harasser might not be harassing the victim based on sex. It may be that a harasser is a straight male and he is harassing a gay male because he's a jerk, not because he has any sexual desire toward that victim. The courts have struggled with this, and I would hope that the jerk could be fired or at least disciplined pursuant to company policy, if not pursuant to Title VII of the Civil Rights Act. Take a look at the simulation that we have on this very issue of same-sex harassment. A female bakery worker complained about being sexually harassed by another woman who harassed both men and women in the same sexual way. A pair of you will be assigned to present that by the client to the HR professional, and we will have the result of that question, Chapter 9, Question 1, in the question pool for the second exam. Here's how the EEOC defines sexual harassment. Note that it can be one of 3 types. Really, type 1 and 2 are in the same category. That is, that there is some sort of submission expected, and category 3 is really the second category, which is sometimes called a hostile work environment. We'll be talking about all of those. If some sort of submission is expected, that's called quid pro quo harassment. In order to prove that, several things. The harasser has to have sufficient authority to influence employment outcomes. The plaintiff has to show that some tangible employment action was taken that was causally related to the rejection or submission to harassment. Take a look at the case in the textbook at page 301, where the response from the employer was to someone complaining of sexual harassment, well, you already know what you have to do. Second type of sexual harassment is called a hostile environment, where the victim is subjected to unwelcome, offensive treatment because of his or her sex. If you've ever seen even one episode of The Office, you know what a sexually hostile environment is. Please, please do not think that that's the way the work environment is. It's a it's a comedy. Uh, Employment lawyers have watched episodes of The Office and have found, on average, 2 or 3 legally actionable sexual harassments in each and every episode. But here's a question for a simulation pair, the woman who worked at a trucking company who complained about a screensaver on a desktop computer with a picture of a nude woman, and she also complained about a tampon hanging from a truck keyring. She worked at a very male-dominated trucking company. What are the legal implications of that? Here's a case in the textbook. A professor complained about sexual harassment, and the college, the university, it was the University of Puerto Rico, and the alleged harasser tried to defend themselves by saying that at the same time this college professor said she was being harassed, she was engaging in joking and very friendly emails with the alleged harasser. Did that make a difference? In a sexually hostile environment case, one of the key factual issues will be whether or not the victim perceived the actions of the harasser as unwelcome. Here are some factors that are used to figure out whether the actions were considered unwelcome or not. Here's a simulation that will be assigned to 2 of you. The woman who had an affair, it was a consensual affair with her married boss, but after she broke it off, she was fired when the boss apparently told his wife about the affair that had just ended. Can she complain about sexual harassment? Was it really unwelcome when the relationship was, at least at one point, consensual? Here are the many forms that sexual harassment can take. Please look at the learning module with a video on whether flirting can be considered sexual harassment. The bottom line is, do not do it. You do not want to have to come home and tell your family that you have lost your job because of sexual harassment. And no amount of explaining that you were just flirting is going to make that any easier. Can an employer be liable for the sexual harassment of an employee by another employee? The answer to that is that yes, the employer can. There are a number of theories for that. Under tort law, the principal is liable for the actions of the agent. The Supreme Court has actually addressed this very specific question and says that if the employer wants to avoid liability for sexual harassment by one of its employees against another, and remember that it's the employer who's the deep pocket and is usually going to be the one sued, the employer has to, number one, have exercised reasonable care to prevent and correct any harassment, and number two, the plaintiff has to unreasonably failed to take advantage of those preventive or corrective opportunities. There's a lot of content in those two. Stop and pause and make sure you understand. Item 1 requires that the employer have really tried, perhaps through training, almost always through training of employees, to prevent, and it must have tried to correct any harassment. And number 2, it didn't work. The plaintiff had to have failed to take advantage of the corrective opportunities. Here are 2 cases with opposite results. In the first case, the city of Racine, Wisconsin, was not able to establish that it had exercised reasonable care to prevent and correct harassment. In the second, the defendant employer was able to establish that the male who was complaining about the harassment had waited too long to complain and had asked the company not to investigate his claims. The company said that it had, in fact, exercised reasonable care. Complaints by males of sexual harassment by females are increasing. Some of you might have seen the movie Disclosure. Coworkers and third parties, customers, can create a hostile work environment, and the standard that would be used to determine whether the employer should be held liable is whether the employer knew or should have known about the harassment. The manager of the restaurant can't just turn away when he sees customers harassing the female servers. So what should the employer do to avoid liability? Establish, communicate, and enforce policies that prohibit harassment. Have a clear policy and train on it. What should be in the anti-harassment policy? Obviously, a prohibition on harassment. Explain what harassment means. Provide a reporting mechanism. Protect people from retaliation if they report harassment. Look at the horrible things that the police department did to a police officer who filed a harassment complaint against her former supervisor in New York. Here are some other things that should be in a good harassment policy. Promise confidentiality in handling complaints. Set up a process. Assure people who complain that corrective action will be taken, including perhaps disciplinary action. As I mentioned before, employers have to respond promptly to stop and correct any harassment. The promptness and adequacy of the employer's response will be measured in light of how serious the harassment was. If it was a really egregious, terrible case, obviously the employer has to act more quickly. Even if a victim says, "I don't want any action taken," the employer has to investigate. Here are some suggestions for questions to ask of the employee who complains about harassment. Take a look at the case on page 323 of your textbook, where an employer supervisor was told by a complaining employee about sexual harassment, and the supervisor said, well, do you really want to tell me about it? And the employee complaining said, well, I really don't. And the supervisor said, good, I really don't want to hear about it. That would not be a good investigation. The accused have rights too. This is very important to keep in mind. Sometimes complaints of harassment can be filed that are not true. A flirting relationship gone bad. Here are some questions to ask the accused. The investigators have to remain neutral. This will be something that many of you as HR professionals will have to do, investigate complaints of sexual harassment. Your job is not to take sides. Your job is to listen to both sides. If there is a finding of harassment, then there have to be some remedies that are designed to respond to how severe the harassment was. If the employee engaged in some pretty serious harassment, there should be some pretty serious consequences, including perhaps getting fired. Look at the case on page 331 of the textbook at a school district where a harasser was found guilty in an investigation and was directed to undergo counseling, but no one ever followed up to see whether he did. And then the harassment continued, and the school district was found negligent for not having followed through. That's it for this set of slides. Our next set of narrated slides will be on the very important topic of accommodating employees and applicants who are disabled, or accommodating employees or applicants if they make a request based on their religion.